I want to go into the weeds. Here from the jury instructions. I'm going to put this up on the screen. I'll read it aloud. In determining whether the defendant conspired to promote or prevent the election of any person to a public office by unlawful means, you may consider the following: violations of the Federal Election Campaign Act, otherwise known as FECA, the falsification of other business records, or violation of tax laws. Now I'm putting on the screen one portion of the verdict slip so that people can see it was a binary choice on each of the 34 counts. And here's my question. Based on the verdict slip, Trump can truthfully say he doesn't know for what he was convicted. Do you agree?
I do agree, and I think we all have that issue. Now, that verdict slip that we just looked at is deceptively simple in its layout. It's a binary choice. Guilty, not guilty, yes, no. But in fact, the charges here are much more complicated. So think of them like if it was a triple-decker sandwich. There's 3 actual layers to each of the 34 counts here. The first layer is a New York State violation of falsifying business records, which is a misdemeanor. The middle layer is, well, they falsified business records in order to violate New York election law, which says you can't try to influence an election by, quote, unlawful means. Well, what are those unlawful means? That brings us to the third layer, which is the sort of 3-part menu that you just showed us. And the judge told the jury, the prosecutor's argument was, well, it could be one, both, or all 3, or maybe some combination of federal campaign finance law, falsifying other business records, which doesn't really make much sense to me, or some sort of tax violation. So we don't know which of those 3 options the jury voted to convict on, and the judge said you don't have to be unanimous as long as you agree it was one of those 3. So there's a lot of uncertainty in what the jury actually decided.
Okay, in the last couple of days, privately by text, I was saying to you, hey, Ellie, have you seen the verdict slip? Can you flip it to me? Because I wanted to see what level of detail they were going to have to provide. You're the expert when it comes to matters of prosecution. Do you agree with me that this is a legitimate appellate issue for Trump? He can put it in the way that I put it. I don't know for what I was convicted.
There are 2 appellate issues here. The first one is what you said. Look, a basic fundamental principle of our criminal law process, of our Constitution, is a defendant is entitled to notice in advance of trial with specificity what he's being charged for, what he's being tried for. That's why we have indictments. Now, the indictment in this case does not specify what the underlying quote-unquote unlawful means are. And in fact, and I found this to be shocking, frankly, the judge did not make the prosecutors commit to any of those unlawful means until we were just about into closing arguments. So that's going to be appeal issue number 1. I was never put on specific notice of what I was being tried for. Appeal argument number 2 is going to be this. One of the bases for conviction here, one of the unlawful means, is a violation of the Federal Election and Campaign Act. Do you know how many times, Michael, we have ever had in the history of this country a state or county level prosecutor charge either as a charge or a subcomponent or an unlawful means or any part of a charge a violation of federal campaign law? The answer was 0.
Probably
now
never.
It's 1. So this is the first, yes, right. Exactly. This is the first time in American history that's been done. And the appeals argument will be when you have a federal regulatory structure around elections, that's for the feds to violate. That's not for state, or in this case, county. Alvin Bragg is a county level prosecutor to enforce, because that would lead to mayhem and that would create problems for federalism, for the notion that federal law has to, no pun intended, trump state and local law.
James Carville, the Ragin' Cajun, was just here. We were talking about the political aspects, David Axelrod as well, but James made reference to Judge Merchan. Judge Merchan's got a big decision coming, right? Whether Trump is going to go to jail. Speak to that issue.
So number 1, regarding Mr. Carville's comments, I respect Mr. Carville enormously. He, I think, was referencing my piece where I talked about the fact that Judge Merchan made a very small $35 donation back in 2020 to a organization that part of its goal, he earmarked the funds were to resist Donald Trump and his radical right-wing legacy. I see that as a major problem. Mr. Carville's right. There was an ethics committee that looked at this and said, you don't have to recuse. Now, but there's a difference between must and should. And I would pose this question to Mr. Carville or anyone along these lines. Would you be okay if in another one of the Trump cases, if the judge had donated a very small amount of money, $35, to MAGA 2020, Trump forever, resist Joe Biden? I don't think so. I don't think James Carville would be okay with that. And I think that's the principle here. Now, as to your question, Judge Merchan is going to have a very difficult decision. The sentence is entirely up to him, sentences him to some prison time.
The form is just the jury vote. It does not have to have all the details and testimony. Those are in the court records and transcript. Like it or not, that is the law. Mike, I totally disagree. It puts Trump at a disadvantage. Trump does not know. Was it the Federal Election Campaign Act? Was it additional manipulation of business records? Was it some amorphous tax violation? Ellie, what's your thought?
Yeah, I agree with you, Michael. I think the caller here, or the viewer, makes a good point, which is the jury form, the jury doesn't write an essay. Here are the reasons for our verdict. You just check a box. But I've done cases like this where there are subcomponents to the charge. I used to do racketeering cases, and you have to prove a certain number of racketeering acts. And we would ask the jury in the form, which of these racketeering acts do you find proven unanimously or not? A, so that the jury will be able to tell us specifically how they made their finding. B, so the defendant has noticed. And C, so we're covered on appeal. And now this is going to be an appeal issue that, frankly, prosecutors could have avoided if they just said, hey, jury, tell us the specific one of those three menu options which you chose.